Hello and welcome to the Beach House 34 podcast. I'm your host, Christine Worth. Welcome to the new subscribers and welcome back to our very devoted listeners. If you're here, you know that I've covered the Darlie Routier trial transcripts from the very beginning. And she's the mother who in 1997 was accused and convicted of murdering her two children in Rowlett, Texas. If you're brand new here and want to start from the very beginning, you'll find all of the trial transcripts in their own playlist on YouTube. Now, at this point, the actual trial testimony is over. The verdict has been rendered or read, and they've decided Darlie is guilty. And we're now in that phase of the trial where we hear from witnesses before they hand down Darlie's punishment. The first person that we'll hear from today is Darlie Kee, and that's Darlie's mom. And yes, they are both named Darlie. Oftentimes you'll hear them called Darlie Kee for mom and Darlie Lynn for her daughter. Now, a few updates for you, at least regarding Beach House 34. I've been working on the website beachhouse34.com for forever. One of the things that I've always wanted to give you guys is a page that has all of the trial images, or at least the ones that I have access to. And just so you know, none of them have any pics of the kids in them. If you want those, you're going to have to go someplace else because I will not put those on my website. As soon as that's done, I will let you know. Now, outside of the podcast, I have a super busy life and I'm working as fast as I can to get that done for you. So, that said, let's get started with the defense testimonies in the punishment phase of the trial. And the next one up to testify in the punishment phase for the defense is Darlie's mother, Darlie Kee. And the direct examination begins by Mr. Preston Douglas. Miss Kee, would you please introduce yourself to the jury and tell them who you are? My name is Darlie Kee, and I am the mother of Darlie Lynn Routier. Where do you live now? I live in Plano, Texas. How long have you lived in Plano? Since 1993. What do you do for a living? I work as an executive assistant to VP at Ericsson Incorporated in Richardson. What kind of company is Ericsson? Telecommunications. They build switches for mobile phones. And how long have you worked for that company? 7 years. Is it safe to characterize your position as a managerial or administrative position? Like office management? Yes. Okay. And how long you used to live in Lubbock? Is that right? That is correct. And prior to Lubbock, where did you live? Pennsylvania. And coming from Pennsylvania to Lubbock, you brought Darlie with you. Is that right? That's correct. You have how many children? I have 3 daughters. I have Danielle Stahl, who is 14 years old. I have Dana Stahl, who will be 17 at the end of this month. Now, does Danielle live with you? Yes, she does. Does Dana? Yes, she does. Before we go any further, can you describe first Darlie, your daughter, for the jury? Darlie is a very kind, sweet person. She is a very good mother. I am not judging you for what your opinion is. I'm telling you I know her better than anybody else in this world. I don't agree with your verdict, and we will continue to support her and fight her. We have not chosen Darlie over these 2 little boys. They were my grandbabies, Devin and Damon. I watched them being born, along with Drake. If I thought she was capable of doing this. Mr. Davis says, I'm sorry, if we could just have this as question and answer, please. And the court says, ma'am, if you could please just answer the questions, please. The witness says, okay. And Mr. Douglas continues. Darlie, have you believed in and have had faith and confidence in your daughter from the beginning? I do. And you understand, and you were in the courtroom when the verdict was read. And you understand that all we can do is move forward. That is correct. And is your confidence and your faith and your belief in Darlie the same as it was before Saturday? Absolutely. Okay. Describe for the jury the relationship between Dana and Danielle and Darlie. She was almost like a second mother to them because of the age difference. A lot of times when I traveled in my business, they would go over to her house, or I went to Sweden this year. So she came to my house and stayed with Danielle, even though Danielle is 14. She just felt like Danielle needed someone there rather than take her out of school and down to the farm. We have a farm also. So she was not only big sister, but many times she was a stand in mom. Is that right? Oh, yes, she was. A very good one. She taught me to be a better grandmother. She really did. What do you mean by that? I just think that when they were growing up, I was thinking more of my career than I was of all this special moments that I have been able to enjoy with them now. Because Darlie always took time with Devin and Damon and Drake, and she would play with them, and on the living room floor and cut out crafts. And she did special things at the school. She was kind to everybody. She is a very good person. Was she devoted to her children? Very much so. I have never seen her harm the children ever. Did you ever see her use what you considered to be inappropriate method or way to discipline the children? Never, never. With respect to what lays before us in the decision of this jury, it means the difference between life in prison and execution. You're aware of that? Yes, I am. Do you have anything that you want to say to the ladies and gentlemen of the jury as to that issue? From June 6th, this family has endured hell on earth. It has been horrible. I don't think any of you can imagine what we have been through. We have not accepted the death of Devin and Damon, nor what has happened with Darlie. We have to deal with that. I have two other daughters out there that will be in counseling for years over this. And I am asking you, if you have any compassion, do not put her to death because she did not do this. Mr. Douglas says, pass the witness. Mr. Greg Davis says, no questions. And the court says, thank you very much for coming, ma'am. The next witness that is coming to the stand is one we've already heard from, which is Darin. This is a second testimony from Darin for the defense, and the questioning is begun by Mr. Douglas Mulder. Darin, was there a situation that I wanted you to go into? You all had a fifth birthday party for Devin, and it was at a park. Do you recall that? Yes, sir. Kind of a picnic buffet type of situation? Yes, sir. All right. Do you recall an instance where Devin was squirting people, or his mother in particular? He was squirting everybody. Was that a water gun that he had gotten for his birthday or something? Yes, sir. Tell us about that, if you would, please. Well, he had just gotten a water gun, one of those great big, huge gushers that holds about 1.5 gallons of water. And he was going around squirting everybody. And he didn't want anybody squirting him or getting him wet or throwing balloons at him or anything else. We had, water fights with the balloons, and everybody had their bathing suits on, and we were just playing around. Okay. And this was all done in fun. Yeah, it was all fun. I mean, that's what the birthday party was for. All right. Did Darlie cut the cake? Yes, she did. All right. Did she caution him about squirting her and squirting the cake? Yeah. Did he go ahead and squirt both Darlie and the cake? Yeah. What, if anything, happened? She just grabbed a little piece of the icing and smeared it on his face. That was it. I mean, did anybody make a big deal out of it? No, it was actually pretty funny. Ever since Devin was little, he hated having his hands dirty, and he was probably the cleanest little boy I have ever seen, but he hated being dirty. And just to do that just kind of made him, just smeared some icing on his face, and his nose. It was no big deal. Now, let me ask you about is it Eileen? Yeah. Eileen and her husband and their children. Right. Out on your boat? Yes. Did you do that? Yes, we did one time. All right. What is your position with respect to whether or not the kids would wear life preservers? Well, first of all, Damon wouldn't even get into a hot tub without a life jacket. He would wear it into a bathtub if he could. So he was real scared little kid. And, the rule is that if they were above deck, because it had a lower deck to it too. So if they were above deck, they would have to wear their life jackets. And if they were below deck, then they didn't have to wear them. So, they wore them all around the dock or anywhere else that we would go. And we would just keep a close eye on them. Was that a rule that you applied to all children who were on the boat? Yes, sir. And Eileen's kids. I had life jackets there for them too on the boat. So they are the big orange kind, not the vest kind like the boys had. But we let them, we strapped them into their little life jackets. All right. And you looked after her children as well as your own, didn't you? Yes, sir. I am the captain. Okay. And she had her hands full with, I believe her husband was sick most of the time on that deal, wasn't he? Yes, he got seasick and I had to take him in and they left early. Mr. Mulder says, I believe that's all. Mr. Greg Davis says, no questions. And the court says, thank you, sir. You may step down. And next up, we have the testimony of Kenneth Waits. And if you remember in the last episode, we heard from his wife, Melanie, who had met Darlie through mutual friends in 1991. So this is her husband, Kenneth. And the direct examination is being done by Mr. Curtis Glover. Ken, you are Melanie's husband. Is that right? Yes. Melanie testified here before the jury a little bit ago just to recall to them exactly what their relationship is. You all live in Mesquite and you have a sign business there in Dallas. Is that right? Yes. Tell the jury how many children you have. Two. And they are what? Boy and girl? One girl, 6, and one boy, 3. Okay. You know Darlie Routier? Yes. Okay. Tell the jury again how it is that you got acquainted with Darlie and her husband, Darin. Well, we first met them at a going away party for some mutual friends. We had not known them until then. Okay. Did you all then get to be social friends after that time? Yes, we did. Did you have occasion to meet their 2 little boys, Devin and Damon? Yes. Tell the jury how you got to know the 2 little boys. Mostly through birthday parties for their kids and our kids. That is when we were around them the most, at the birthday parties for our kids. Okay. Actually, your wife and Darlie became fairly close friends. Yes, they did. You and Darin were friends, but not so much as your wives? No. They shopped together and this sort of thing? Yes, they did. Okay. Describe for the jury, if you would, what you observed about Darlie Routier and her relationship with her children and her family in general. Seemed to be pretty normal relationship with her family. I mean, they took the kids to do a lot of things. I mean, they took their kids everywhere. They took them all kinds of, they were always with, most of the time I was around them was like at birthday parties and stuff. So it was with the kids almost all of the time when I saw them. Was their devotion to their children so outstanding that it was a subject of remark on occasion? It seemed to me that they really spoiled the kids pretty much. They spent a lot of time and money on the kids. I think you perhaps had an occasion to give a surprise birthday party for Melanie. Yes, I did. When was that? It was June the 1st, Saturday before the kids were. Okay. And you just invited your friends and your wife's friends. Her friends and my friends. I even talked to Darlie about bringing over something, a dish. Okay. Did Darlie and Darin come? Yes, they did. Did they bring any of their children? They just brought the baby, Drake. Okay. And why is that? They didn't think that kids would be there. They thought it was more of an adult party. And of course, the baby was too young to leave with anybody. Okay. During the course of that party, did you have occasion to notice anything about Darlie as far as being concerned about the 2 boys at home? Yes, she called them a couple of times that day. She asked to use the phone. She wanted to check on them. Seemed like one of them may have been sick or something. I don't remember why, but she called a couple of times to check on both boys. Okay. Did they have occasion then to leave the party early to go home? They left. She said they had to leave because the boys wanted them to come home, come get them. Were they at a babysitter? Yes, they were. Okay. This jury has found Darlie guilty of murdering those 2 boys? Yes, I do. Can you accept that? No, I sure can't. Okay, you think she's capable of doing that? No, sir. No way. I guess you know yourself well. You are what age man? 28. Okay. Do you feel like you are a judge of character? Yes, I do. Mr. Glover says, thank you. Pass the witness. And the cross examination is being done by Mr. Greg Davis. Sir, if you are a judge of character, what kind of person would kill these two children in cold blood the way these two were? It would be a pretty heartless person, a pretty evil person. Really, someone kind of out of their mind. Mr. Davis says, no further questions. The court says, you may step down, sir. Next up to testify is Sarilda Routier, who is Darin's mother and obviously Darlie's mother in law. And the direct examination is being done by Mr. Preston Douglas. Sarilda, you testified earlier in the trial, but just to remind everybody, in case it's been a little while, you are Darlie's mother in law. Yes, I am Darlie's mother in law. And you are grandmother of Damon and Devin and Damon and Drake and Dylan. You testified earlier in this trial that you believe very much in your daughter in law. Yes. That you believe in Darlie. Yes. And the jury has found that her guilty of your two grandchildren. I want to ask you, do you still maintain your confidence and your belief and your faith in Darlie? I most certainly do. You were in here when the verdict was read. Unfortunately, I was. And you understand that all that is left now is to move on. Is that right? That's what I'm told. You understand that the jury is faced with the decision of Darlie Routier's life between execution and imprisonment for life. Yes. Now, I want to ask you if you have any thoughts you want to share with the jury. Well, to be really truthful, I am still in shock. I didn't prepare myself for that at all. I don't know where we all were, but yes, I understand that that's all over. I don't know how y'all came to that decision, but I know it wasn't easy. I'm sure it wasn't. I hope it wasn't easy. But of course, I don't have to tell you this. I think you are wrong. But what I do want to tell you is that, you have made a decision and we all have to live with it. But there is still another decision. For goodness sakes, if you make the decision to put her to death, if something happens and we finally find this man, whoever did this, she could be gone. And then you will have to. Mr. Davis says, I'm sorry. Could we please have this in a question and answer? And the court says, sustained. Please just let's ask in the question and answer form, please. And the witness says, well, my statement. And the court says, well, wait a minute until you are asked a question. And the witness says, okay, I'm sorry. Mr. Douglas then asks her, Sarilda, let me ask you this. Obviously, you believe that it's important that Darlie's life be spared. Yes. Okay. Tell the jury why you believe that. Well, for one thing is that, this decision wasn't just for Darlie against Darlie. It's against all of us. Our whole family has been through so much. I lost those two grandbabies. They will never come back to me. Please, please, don't do any more to us. I am just begging you, please. I mean, I have a daughter that's under sedation. I have a husband that may have a heart attack. They lost their home. You don't know the hordes of people that you are affecting. I know you made the decision the best that you could, but you have a right to make this decision again. This is a new decision. I mean, my goodness. I mean, dig down deep in you somewhere and just don't make it any worse. Please, please do not make it any worse. Don't do any more to us. Okay. Mr. Douglas then says, Sarilda, thank you. I'll pass the witness. And the court says, Mr. Davis. And Mr. Greg Davis begins his cross-examination. Mrs. Routier, you remember I believe it was December, that you called me one day? Yes. Do you remember that conversation that you told me? I remember well. That if your daughter-in-law was guilty of this offense? Yes. You thought she ought to die? I said if she did it, but my daughter-in-law didn't do it. You want to recall the wording of that conversation. No, ma'am. Again, if she's guilty, she ought to die. If she did it, but she did not do it. Mr. Greg Davis says no further questions. And the witness says she most certainly did not do it. And the court says, thank you, ma'am. You may step down. Your next witness, please. At this point, Mr. Mosty says, Your Honor and ladies and gentlemen of the jury, the defense rests. Mr. Greg Davis says, state closes. Mr. Mosty says, defense closes. And the court says, all right, ladies and gentlemen of the jury, that is all the testimony you will be hearing in this case. What has to happen now is I've got to put together a charge of the court. We have it done, and the lawyers are going to remain. We're going to get that ironed out tonight. So you will be recessed until 9 o'clock tomorrow morning, at which time you will hear arguments from both sides in this phase of the case. It will be yours to decide. And then that evening, the jury goes back to their hotel rooms or wherever it is that they go. And they come back in the morning. And at this point, the charge to the jury is ready. And it opens like this. The jury is not present at this point in time. And so let's begin. The court says, all right, let the record reflect that these proceedings are being held outside the presence of the jury and all parties of the trial are present. Have both sides read the charge of the court? Miss Sherry Wallace of the prosecution says, yes, sir. Mr. Douglas says, yes, Your Honor. And the court says, okay, I believe the defense wishes the failure to testify portion removed. Is that correct? Mr. Mosty says, yes, sir. The court says, does the state have any objection? Miss Wallace says, no, we don't, Your Honor. But we would request that you inquire of the defendant if that is her desire as well. And the court says, is that your desire, Mrs. Routier? And the defendant, Darlie, says, yes, sir. And the court says, all right. Miss Wallace says, thank you, Your Honor. The court says, will the state still object to my removing that from the charge? Miss Wallace says, no, provided the defense doesn't want it in and they've objected. We just heard them. We will concur with that. The court says, all right, fine then. The motion is granted by the court. The defense's motion is granted. We will remove that portion of the charge as to the failure to testify. The rest of the charge is satisfactory to both sides. Mr. Douglas of the prosecution says, no, Your Honor, if I might respond. And the court says, oh, I'm sorry. And Mr. Douglas says, the defendant objects to the anti-sympathy charge as written in, as in total, presented in the charge. I would provide McFarland versus State, which references the charge, and at this point, this is not available in the transcripts. And then it continues. Also cites Wheatfall versus State in regards to and this again is missing from the transcripts, anti-sympathy charge. And in Wheatfall, which is a court of, and this is again missing, criminal appeals case, 1994, it says that the giving of that charge may not be error, but the court specifically said that it does not pass on whether there is any statutory authority to give that charge. And I believe, as the court knows, there is no statutory authority for giving that charge. Thus, giving that charge is purely discretionary with the court. And in that regard, I would submit it should not be presented. Let me expound on it a little bit. If you have a charge as required by Henry, which says that, and this is redacted, you are to consider mitigating circumstances. And in the charge, you say, and as the court has instructed the jury, you're going to say that they shall consider mitigating circumstances, which I think is appropriate. And if you say, on one hand, you want them to consider mitigation, and in that charge, you say that mitigation includes anything about the defendant's background, character, or anything personal about the defendant. And then on the other hand, you say, well, you cannot consider sympathy, then you are contradicting the Penry charge and you're contradicting the mitigating, and this is redacted, evidence charge. And because there's no statutory authority for being in the charge, I believe it's improper to give it. It's discretionary and there is no statutory basis for giving it. And we object on that basis. And the court says, okay, objection overruled. Anything other than that? Mr. Mosty of the defense says, let me say one thing to that. I disagree with Mr. Douglas putting it in the discretionary part. What the court held in that case was there was not an abuse of discretion, but the statutory objection, I don't believe, was raised in that case. And that's the thrust of our objection is no statutory authority. Mr. Douglas of the prosecution says, if I might just add one thing to be clear, the court specifically said nobody raised in that case the fact that there's no statutory authority, as if it was willing to say we'll revisit that issue because there was no authority to give that charge. The court says, all right, thank you. And Miss Wallace says, and Judge, and the court says, other than that, yes, Miss Wallace. Miss Wallace continues, I said the state concurred in the request to remove the failure to testify. We're not asking for it to be removed, but understand that the defense is. And we're satisfied with it in, but if they want it out, we understand your ruling. And the court says, thank you. Other than that, does the defense have any objection? Mr. Mosty then says, yes, we object to the instruction on parole. That is an inaccurate statement of the law that she would have to serve 40 years. It also contradicts with the second full paragraph of the charge, which says that the sentence is mandatory death or confinement in the penitentiary for life. And all the charge does is suggest that, in fact, there is some parole law applicable to the case, and we object to including it in there. And the court says, overruled. Other than that, is there any defense objection to the charge? Mr. Mulder says, I just want to re-urge all of the arguments made. And the court says, is the rest satisfactory? Other than that, is the charge satisfactory to the defense? Mr. Preston Douglas says, yes, sir. The court says, all right. And so, Ms. Halsey, if you will be kind enough to mark this as the next court's exhibit D, all right? Make this exhibit D. And then the court continues. All right, so we're going to bring the jury in. I'll read the charge of the court. Then we will have arguments now. So we get everyone in a row here, so to speak. Who will argue for the defense? Who is going to open for the state? Mr. Shook? Miss Sherry Wallace says, I will, Your Honor. And the court says, Miss Wallace, all right. And by agreement, 90 minutes aside. What warnings do you want, Miss Wallace? Miss Wallace says, if you could let me know when I've used 30 minutes and 15 minutes thereafter. And the court says, okay. And who will argue for the defense? What order? Mr. Glover says, Doug, are you going to open? And Mr. Douglas Mulder says, yeah, I'll open, Judge. Mr. Glover says, I'm following him, Judge. The court says, pardon? Mr. Glover says, I'll follow him, Judge. And the court says, okay. How long do you want, Mr. Mulder? And Mr. Mulder says, I don't need to be called. I don't know how long I'm going to use, maybe half an hour, maybe 45 minutes. And the court says, well, do you want me to let you know when you have used certain time limits or gone past a certain time? Mr. Mulder says, no, that's quite all right. Thanks. And the court says, all right. Well, then, who will follow that? And Mr. Douglas says, after Mr. Glover, then I will. I just need 10 minutes. Well, Mr. Mulder, I will warn you at the end of each 30-minute segment. Is that clear? So everybody will know the time they're using. Now, we will break. The jury is going to need a break about an hour and 15 minutes. I will try to wait until somebody, whenever we can break, but they're not going to be able to sit for 3 hours. Mr. Mulder says, well, if you're going to do that, then I suggest that you break at the end of Sherry. And the court says, Mr. Mulder, I will determine when we break. Mr. Mulder says, well, Judge, listen, that's fine with me, but I just don't want to be interrupted in the middle of my argument. And the court says, well, we hope that you're not. Mr. Mulder says, well, I want that understood, Judge. And the court says, thank you. All right. Mr. Mulder then continues. I want that understood, Judge. I don't want to be interrupted in the middle of my argument. Now, if you want to recess prior to the time that she reaches at the conclusion of her argument, that's fine and dandy. I don't want to be interrupted in the middle of my argument. And the court says, if the jury wants to break, Mr. Mulder, we will break, and we'll have plenty of time. Mr. Mosty says, I don't think that's an unfair request that Mr. Mulder's argument not be interrupted. And the court says, gentlemen, let's don't get I normally don't interrupt people in the middle of their argument. And Mr. Mulder says, well, if I argue for 45 minutes, that's going to take it to an hour and a half. And the court says, well, all right. If I see a juror with their hand up, we're going to be breaking. I just want to warn you of that. Mr. Mulder says, well, Judge, I suggest that you take that up with the jury before I get up to argue. It's real simple. The court says, I have. Thank you. And we understand that there will be a total of 90 minutes per side. Total. With that understanding, let's bring the jury in, please. Mr. Mosty says, could we wait a minute, Your Honor? Can I check on something? And the court says, yes, all right. And Mr. Mosty says, will that be okay? And the court says, all right. And Mr. Mosty says, Your Honor, we object to starting until Mr. Routier gets here. I think that's not an unreasonable request after a 5-week trial. And the court says, thank you, overruled. Let's bring the jury in, please. Well, when do you think he will be here? Mr. Mosty says, if the court will give me a few minutes, I can go check. And the court says, all right, go ahead and check and see where he is. Just hold the jury a minute to see where Mr. Routier is. And then the court says, all right, are they here? I thought they were coming up the stairs. Let the record reflect these proceedings are being held outside the presence of the jury and all parties of trial are present. These proceedings today began at 9:00 a.m. sharp. It's now 14 minutes after 9 o'clock. We have recessed for 5 minutes. And Mr. Mosty, what is the result of your search for the Routier family? Mr. Mosty says, I have someone going to check on him. The place where he is staying does not have a phone. Court says, well, it's 9:15 now. Mr. Mosty says his brother is going on his way there. And the court says, all right, thank you. Well, it's 9:15 now. The court feels that we have waited long enough. We have a jury in the jury room ready to go. We have 3 hours of argument ahead of us. So the court is now going to proceed. If you will bring the jury in, please. And at this point, the jury is brought into the courtroom and the court says, all right, be seated, please. Let the record reflect that all parties in the trial are present and the jury is seated. Ladies and gentlemen of the jury, what is going to happen now is I'm going to read you the charge of the court. That's the law in this case. Then you will hear arguments for both sides. Then the case will be yours to decide. The charge of the court, ladies and gentlemen of the jury. By your verdict, returned in this case, you have found the defendant, Darlie Lynn Routier, guilty of the offense of capital murder. It is necessary now for you to determine from all of the evidence in the case the answers to certain questions called special issues in this charge. The mandatory punishment for capital murder is death or confinement in the penitentiary for life. You are instructed that in answering these special issues, you may take into consideration all of the facts shown by the evidence admitted before you in the full trial of this case and the law as submitted to you in this charge. During your deliberations in this phase of the trial, you must not consider, discuss, or relate any matters not in evidence before you. You should not consider or mention any personal knowledge or information you may have about any fact or person connected with the case which is not shown by the evidence. You are instructed that if any evidence has been introduced during the course of this trial concerning the defendant's involvement in offenses or bad acts other than the offense on trial, you cannot consider such evidence for any purpose unless you first find from the evidence beyond a reasonable doubt that the defendant committed these other offenses or bad acts, if there were any, and even then, you may only consider the same in determining the answers to the special issues. If you do not so find or believe from the evidence, or if you have a reasonable doubt thereof, you must wholly disregard such evidence. You are further instructed that you are not to be swayed by mere sentiment, conjecture, sympathy, passion, prejudice, public opinion, or public feeling in considering all of the evidence before you in answering the special issues. The burden of proof in special issue number 1 rests upon the state, and it must prove the affirmative of such issue beyond a reasonable doubt. A reasonable doubt is a doubt based on reason and common sense after a careful and impartial consideration of all of the evidence in the case. It is the kind of doubt that would make a reasonable person hesitate to act in the most important of his own affairs. Proof beyond a reasonable doubt, therefore, must be proof of such a convincing character that you would be willing to rely and act upon it without hesitation in the most important of your own affairs. In the event you have a reasonable doubt as to the answer to special issue number 1, after considering all of the evidence before you and these instructions, you will answer the special issue no. In deliberating on special issue number 1, you shall consider all evidence admitted at the guilt or innocence stage and the punishment stage, including evidence of the defendant's background or character or the circumstances of the offense that mitigates for or mitigates against the imposition of the death penalty. You are instructed that you may not answer special issue number 1, yes, unless all jurors unanimously agree to such answer. Further, you may not answer this special issue no, unless 10 or more jurors agree. It is not necessary that members of the jury agree on what particular evidence supports a negative answer, that is, an answer of no, to special issue number 1. You are further instructed that if the jury makes an affirmative finding to special issue number 1, that is, an answer of yes, then the jury shall answer special issue number 2. You will answer special issue number 2, yes or no. You may not answer special issue number 2, no, unless all jurors unanimously agree to such answer. And you may not answer such issue yes, unless 10 or more jurors agree to such answer. The jury, however, need not agree on what particular evidence supports an affirmative finding on special issue number 2. In answering special issue number 2, you are instructed that you shall consider mitigating evidence as evidence that a juror might regard as reducing the defendant's moral blame worthiness. And then we have the 2 special issues, which I will read now. Special issue number 1. Is there a probability that the defendant would commit criminal acts of violence that would constitute a continuing threat to society? If the jury returns an affirmative finding on the issues submitted above, then you shall answer the following special issue. Special issue number 2, taking into consideration all of the evidence, including the circumstances of the offense, the defendant's character and background, and the personal moral culpability of the defendant. Is there sufficient mitigating circumstance or circumstances to warrant that a sentence of life imprisonment rather than death sentence be imposed? You are further instructed that your verdict shall be arrived at by due deliberation and not by drawing lots or any other method of chance. The answers to the special issues shall be signed by the presiding juror. You are the exclusive judges of the facts proved, the credibility of the witnesses, and of the weight to be given to their testimony. But you are bound to receive the law from the court, which is herein given you, and to be governed thereby. And that is signed by me, Mark Toll, presiding judge. Now, the next 2 pages contain these special issues. And depending upon your answer, the presiding juror will sign, of course, the bottom of the issue, assuming it's answered. And depending upon the instructions, you will answer one or both of these issues, depending upon the answers thereto. And Mr. Wilson will sign the ones that you decide upon, and if he will print his name, please. And at this point, I'm just going to end this episode, because then we move into the punishment phase arguments, which will get a little long-ish. So anyway, longer than I want this episode to run. So anyway, let's go ahead and start with the recap. So first, we have Darlie's mom, who is Darlie Kee. She gets on the stand and she gives a little bit of background information about herself. And then she begins to talk about her daughter and how the jury was wrong. And she knows that Darlie would never be capable of doing anything like this until the prosecution objects to her comments and asks if this could just be question and answer only. You can just feel the emotion, though, in her testimony so far. She obviously has had this on her mind for some time, and she wants to get this known to the jury that they have made a terrible mistake. We learn also that because of the age difference in Darlie and her sisters, that Darlie is the one who usually would take care of them when their mom wasn't around. Now, it was kind of odd, I thought, when she was asked if Darlie was devoted to her children, and she said very much. Okay, that's not what I thought was weird. But then she says, I have never seen her harm the children ever, which wasn't a question that was asked. So it kind of came out of nowhere. Darin then takes the stand again, and the topic of the birthday party at the park was addressed. So, if you recall, in an earlier testimony from Eileen Shermer, she said the following, that she and her family were at this birthday party. And Eileen's story was that Darlie had told everyone to stop, squirting with the water guns. Damon sprayed her. So then, after Damon did this, according to Eileen, Darlie took a piece of birthday cake off the table and shoved it into his face, saying that she held his head and she shoved the cake in his face, and how everyone was kind of shocked by this and they all stopped playing. Darin, however, explained it a little differently. He said that Damon did continue to squirt the water gun, and it not only ended up getting on Darlie, but on the birthday cake as well. But she didn't shove the cake in Damon's face. She instead took some frosting from the cake and smeared some on his face and his nose. He then addresses the boat incident where Eileen said that Darlie had told her that Damon and Devin did not know how to swim, yet they did not wear life jackets while on the boat. Now, Darin pointed out that if you were below deck, you did not have to wear one, but on the deck itself, you did. And how Damon wouldn't even get into a hot tub without a life jacket on him. However, Darin never did explicitly say if on this same day that Eileen was talking about going on the boat, if the kids had their life jackets on or not. Now, Kenneth Waits is next on the stand. He is a friend of the Routiers. He's Melanie's husband. She testified earlier. And he talks about a time when they had a party and the kids were at a sitter's and the Routiers just brought Drake. She said, Darlie had said to Kenneth at this party that one of the boys didn't feel well. And so she called at least twice to check on them. So there's a few things here, though, that stood out to me. First of all, if one of them didn't feel well, why were they at a sitter's? And then Kenneth said that they left the party early to go home because the boys wanted them to come home, but I thought they were at the sitter's. So he might have misspoken and meant that they were with a sitter at their house. I don't know. They then get into a discussion about the charge to the jury, what should be put in or left out, and then the time limits on how long each attorney will take. Mr. Mulder of the defense, he gets a little demanding with the judge, doesn't he, when he asks that, hey, do not interrupt me during his closing. Now, this is understandable, but the way that he goes about it just seems, again, like he's arguing with the judge. And before the closing or the punishment phase arguments, I don't know if you want to call them closing, but the punishment phase arguments go that are now going to start in the next episode. We do find out that this whole thing starts at 9:00 in the morning. Okay, this whole thing is going on at 9:00 in the morning when the charge to the jury is read. And it's like 9:14 and Darin is still not there. So they're trying to find out where he is, trying to get him there. They sent his brother, I guess, to go find him, to bring him into the courtroom. But nonetheless, that's where we are right now. So in the next episode, we will get into these punishment phase arguments, find out what time Darin showed up, and continue with the episode. So that's all for this one. Please like and subscribe if you haven't done already. Subscribing does not cost a thing. Click that bell if you're on YouTube to get notified of any upcoming episodes. And thank you. Thank you all so much. We will talk very, very soon. Bye for now.